I am Shanna Welsh Levin. I am the lead attorney at SoCal Realty Law. At SoCal Realty Law, we protect the interests of real estate investors and real estate professionals. We do that by removing unwanted tenants, conducting successful transactions, and pursuing justice for property owners who were harmed by others. We provide legal solutions to real estate problems, and we do a great job of it. So I'm very happy to share some of my knowledge, but we also have a team of other legal professionals who help me every single day to accomplish all of the things that we do for our clients. Every month we bring you this webinar, and every month is a different topic. It's different every time. And so next month, I will let you know when the webinar is next month. At the end of the webinar, I just have to look up the date and make sure I give you the right date. And then I believe we also know the topic, and maybe I can find that topic to tell you that. So today we're doing attorney Q&A. I have received your questions and I am going to give you some answers. So here's my PowerPoint. All right, so the first topic, I have this arranged by topic. I organized your questions by topic. First, we'll do residential questions relating to security deposits. Question number 1, if the tenant declined to do a pre-move-out inspection, can they contest the deductions made with photos as proof of the damages, that the damages were caused by the tenant? So what's referred to here is that when you have a lease with your tenant, you should always have a notice in your lease of the tenant's right to a pre-move-out inspection. That inspection has to be requested by the tenant. If requested, it must be conducted within the last 2 weeks prior to the tenant moving out. The landlord is obligated to conduct a pre-move-out inspection, and the landlord's duty during that inspection is to make a list of anything that they see that's in plain view that may be something they want to deduct from the security deposit. They give the list to the tenant, and it gives the tenant an opportunity to make repairs to the things that the landlord saw. What is off limits during that walkthrough, or things that are not in plain view. And then what is to be determined is how much are those repairs going to cost, and whether the landlord has identified things that are ordinary wear and tear. And it's not an opportunity to dispute those things. It's just a chance for the tenant to be informed. If you don't have that notice in your lease agreement, you can serve the notice when you receive the communication from the tenant that they plan to move out. So the landlord has to, by law, provide that notice. You can put it in your lease or you can serve it later. So in answer to the question, if the tenant receives their right to conduct the move-out inspection and they choose not to, but then later on when the landlord provides their accounting of the repairs that were made, the tenant wants to dispute the accounting, probably by taking the landlord to small claims court. So do they waive the right to contest the landlord's accounting by declining to do that pre-move-out inspection? The answer is no. So the tenant does not waive the right to contest the landlord's accounting of their security deposit just because they didn't do the pre-move-out inspection. What the Civil Code section 1950.5 requires is that the landlord deduct only what is reasonably necessary, and that is not considered normal wear and tear. So only things that are beyond ordinary wear and tear can be deducted. The tenant still has the right to contest that accounting because the purpose of the pre-move-out inspection is for the landlord to notify the tenant of things that might be deducted from the security deposit. On the other side of the coin, however, if the landlord declines the move-out inspection or fails to provide the notice, the statute 1950.5 states that the landlord does not have a right to withhold anything from the deposit. So the landlord has to return the deposit in full in order to comply with the law if the landlord refuses the move-out inspection or doesn't provide the notice. So that is, that's the overarching law behind that question. And currently the law has changed. You, as a landlord, you are now required to take photographs at several times during the tenancy and before the tenancy begins and after the tenancy ends. So basically 3 times. So the landlord has to take photographs of the damage when the tenant moves out and has to take photographs after the damage is repaired. And then they have to take photographs again when a new tenancy begins, at the beginning of the new tenancy. So three, in my mind, it's 3 times when the landlord needs to be documenting it. And you have to save those photographs, and now you have to provide them with your security deposit accounting, as well as receipts for the repairs. So the next question is, are blinds considered a landlord's responsibility or a tenant's responsibility when they need to be replaced? This goes to the useful life rule. So items that are in the property, furnishings, such as blinds, have a useful life. And depending on the quality of the blinds, they might be intended to last 1 or 2 years, or they might be intended to last 5 years or more. So depending on the quality of the blinds, the landlord determines what kind of damage has been made and whether the damage can be repaired or whether the blinds need to be completely replaced. And then the useful life rule says the landlord can charge the tenant for the loss of the useful life of the item. So the item has undergoes ordinary wear and tear. The item gets dusty, it might get faded. There's a difference between that and blinds that get torn, blinds that get pulled down or damaged in other ways. So if the damage was beyond ordinary wear and tear, if it was caused by the tenant, then the landlord can only charge for the difference between what the useful life of the item was meant to be and the actual life of the item. So if the item was meant to last for 3 years and it only lasted for 1 year, the tenant was only there for 1 year, and they had to replace it, they can only charge the tenant for 2/3 of the cost of replacing the item. So if you lose 2/3 of the time that the item was meant to last, you can charge the tenant for that amount for the replacement item. I don't know if I'm explaining it very clearly. It is a bit technical. The freebie, one of the freebies that I'll send you with this webinar is the California Tenant Handbook, which is a publication from the Department of Real Estate, and it lists the useful life for certain items like paint. And depending on the length of the tenancy, paint can be charged to the tenant depending on how long the tenant lived there. After about 3 years, you can't charge the tenant for repainting the unit. So the handbook has a bunch of information of different kinds of items and how they recommend those things be charged to the tenant. Next question. In California, when a landlord complies with the 21-day requirement by providing an itemized list of damages, even if it's based on estimates, under what circumstances can a tenant still claim bad faith and seek double or triple the security deposit? So the scenario in the question is that the landlord has complied with the 21-day requirement and complied with what the landlord believed to be the requirements under the statute. But the tenant comes back and says, you've acted in bad faith. So question number 1, what does bad faith mean? So the statute 1950.5 subsection H7 and subsection M, so particularly subsection M, states that bad faith punitive damages can be applied whenever the facts warrant that an award, regardless of whether whenever the facts warrant that award. This is what it says, quote, whenever the facts warrant that award, regardless of whether the injured party has specifically requested the relief. This is ambiguous, right? What this means is that a judge has discretion to apply the bad faith part of the statute whenever the judge thinks that the facts warrant that award. Whenever the judge thinks that bad faith has happened, the judge calls it like they see it, and then they can award up to twice the amount of the security deposit in addition to the actual damages. So the actual damages include the full security deposit. If the judge thinks that the landlord has acted in bad faith and is not entitled to withhold any portion of the deposit, then the landlord may have to return the entire deposit as actual damages. Plus, the court can award 2 times that amount as punitive damages. So the tenant may get 3 times the amount of the security deposit as their total damages. In small claims court, the limit of a judgment is $12,500. So the court can't award anything more than that. And I think the other point here is that there's no firm legal definition of bad faith. Bad faith could include fraud, misrepresentation. If the landlord refuses to provide photographs and receipts for the repairs, that could be considered bad faith because it's basically indicating that the landlord did not do the damages and has no proof of the damages and therefore could be lying. It could go on whether the judge thinks that the landlord is credible, whether the judge thinks the landlord is lying, and also the behavior of the landlord. So, yeah, no firm definition there. Okay, next question. In Southern California, if a tenant reports a burglary, but there's no police report, there's no evidence of forced entry on surveillance, and nothing was stolen, who is legally responsible for repair costs if the incident may have been misrepresented? So this question is a little confusing because it doesn't indicate that any harm was done. A burglary occurred, nothing was stolen. It doesn't say that anything was damaged, so I'm not sure what is being repaired. I am going to assume that what was damaged was, well, there's no evidence of forced entry. Maybe, I'm not even sure what the scenario is, but what was the impact on the landlord? What was damaged? So a landlord is responsible for repairs to things that are required under the California Civil Code and things that are required under the California Health and Safety Code. New law says that the landlord's required to provide a working stove and a working refrigerator. So if a stove and a refrigerator are damaged, you gotta fix those. Doors have to lock, windows have to lock, windows can't be broken. So the place has to be secure to the weather elements as well as to any kind of entry from people. You have to be able to lock your doors. Those are the sorts of things that must be repaired. Thinking about what kinds of things might be damaged in a burglary. However, if the landlord can prove that the tenant caused the damages, so the tenant is now trying to cover up damages that they caused by saying a burglar came in and did that damage, the landlord can make the repairs and then charge the tenant for the repairs. Then the dispute becomes whether the landlord or the tenant can prove who caused the damage. So the tenant, if the landlord takes the tenant to small claims court and has no proof that the tenant caused the damage, it's their word versus the tenant's word, then the judge has to make a determination based on the credibility of the testimony. But it says that there's some surveillance, there's no police report. So I think the circumstances might indicate that there is some evidence that might support one side or the other. The claims that a landlord would make under the circumstances would be fraud and damage to the property. So the landlord could sue the tenant for misrepresentation and could sue them for damage to the property if they have to make repairs and think that the tenant was responsible for it. Right. Next question is on, a bunch of questions are on evictions. So, evictions. The first question is that a home, oh, and by the way, the similar subject matters come up in the responses to each of these questions. So, compliance of the lease agreement is a big one. Determining whether the tenancy is exempt or not exempt from tenant protections, and whether the eviction is the basis for the eviction is considered an at-fault just cause or a no-fault just cause. At-fault is a type of eviction where the tenant did something that is resulting now in a basis for their eviction, so they were at fault for their own eviction. No fault is that the reason for the eviction was not the fault of the tenant, it's something that the landlord needs and is doing. There are certain reasons that are considered no fault evictions. So the first question is, a home is rented by 3 people. 2 of them decide they need to move out and they leave the third person. This third person has developed mental issues and would not qualify to rent the apartment on their own. What is the earliest opportunity to get the third person out of the home? So some questions arise here, and then something else came to mind as I was reading this again. I would need to know whether it's a single lease agreement with 3 people on it, all of whom are kind of partners in the lease agreement, or does each of the tenants have their own separate lease agreement? Another question is, who is paying the rent? How has it been paid? Has rent been accepted directly from the individual who's staying behind? Have they been paying separately every month? 3 people paying with 3 separate checks, or has one person been paying for all of them? And under the lease agreement, who is identified as having financial responsibility for the lease? Other factors that might be involved here that we would discuss if I were doing a consult on this would be whether there is a separate move-out agreement with any of the individuals who are moving out. Was there any change to the lease agreement as a result of a separate move-out agreement? So I'm going to use the following scenario to answer the question. In my scenario, all 3 individuals are on the same lease agreement and each was paying their own portion of the rent separately. So one lease agreement, all 3 are named as tenants who are financially responsible for the lease, but they're each paying separately to the landlord. Under contract law, 2 of the 3 tenants who want to get out of that lease can't unilaterally terminate the lease, and they can't terminate it for all 3 of them. So they can't just leave and say, see you later, landlord. That would be a unilateral termination. But they also can't go to the landlord and say, we want to terminate the lease, but he doesn't. So the landlord and the 2 of the 3 tenants agree to terminate it. All of the parties involved have to be a part of the agreement. The other factor, legal factor involved here is that when you have a single lease agreement, and certainly depending on how the lease is written, but unless you really consider stating in the lease the percent interests of each of the separate tenants, like they have separate interests. If you just say, Tom, Dick, and Harry, they are the 3 tenants on the lease, and it doesn't say anything else with regard to their separate interests, they all will have an equal and undivided responsibility for the contractual obligations. which means that they are all responsible for the full rental payment. If one of them decides not to pay, the other two have to pick up the payment. So the most likely way to get this tenant out would be to see if he can pay the full rent. It doesn't matter if the landlord wouldn't have qualified him individually. He is now the sole occupant of the property. He's now responsible for the full monthly rental payment. And if he can't make the full rental payment, then the landlord would be entitled to provide a notice to pay and then a notice to quit and terminate the tenancy that way. Sometimes when the tenants are paying separately, they might argue that they're only responsible for the portion of the rent that they are paying. And that may be true depending on how the parties have behaved. Whether the landlord has issued a notice just to one of them when they didn't get one of the checks and did a 3-day notice to pay just to the one for their portion of the check and treated them as having separate interests versus treating them as a family, as a community. So non-payment of rent would be the most likely scenario to get this person out. But I would also need to know whether the lease is in compliance with the law, because we can't terminate any tenancy with a lease that's not in compliance. And we also would need to know whether the lease is exempt or not exempt from tenant protection laws, and whether any rent increases have been done that exceeded the rent cap. So we would have to look very carefully at how we proceed with an eviction. Whoops, let me go back. I didn't mean to hit my slide. Okay, there's one other dispute that had arisen that I handled, and the opposing counsel for the tenant raised some interesting issues. This was a month-to-month tenancy, and one of the tenants gave their notice that they were moving out, and the other tenant stayed on. And the question was whether the tenant that moved out could still be held financially responsible under a month-to-month tenancy. So there is a case that explicitly states that a lessee is not liable for a month-to-month holdover by a co-lessee who continues in possession of the property when one lessee notified the landlord that they are no longer connected with the co-lessee and that the person is moving out. So after the lease is terminated by one co-lessee on a month-to-month basis, the other one stays on, then case law seems to indicate that the landlord, after the 30 days, 30-day termination that the tenant gives the landlord, after that, the tenant that moves out is no longer responsible, and the landlord can't enforce the terms of the lease against that tenant. Only the remaining tenant is financially responsible. Okay. But it depends on the circumstances, and in that case, we had to carefully review each step that had been taken by the tenants and when one tenant moved out and how much rent each one had paid. So we do have to be careful about applying different facts to case law and to statutory law. What's the average amount for removal of a tenant in an unlawful detainer suit? So it could vary from one attorney's office to the next, but our average case value for an eviction case, meaning not going all the way through to trial, but like the average, somebody comes in, they want to get a tenant out. We start by serving notices, and then that's what we call phase 1, bringing them into compliance and serving notices. We have phase 2, which is where we file the lawsuit and we litigate the matter. And then phase 3 is where we have to set the case for trial, prepare for trial, and appear for trial. And then there might be post-judgment after trial. And phase 2 can also include judgment when we have a default judgment, a case that doesn't have to go to trial, but does go to judgment. Anyway, so all of these phases and all of the different cases that we do, average case value is $4,500. So many cases resolve for much less than that. Cases that go to trial generally costs a lot more than that. A case that goes to trial is generally going to cost between $5,000 and $15,000. It just depends on a variety of factors that are involved. And some of those cases can be a lot more expensive than that when we end up having discovery litigation issues. Discovery is where an attorney comes on board for the tenant and wants to issue written questionnaires to the landlord, which the landlord then has to write out responses to and then produce documents. Tenant advocates can cause a lot of delay and a lot of expense by going through litigation procedures. And that is what often becomes expensive. I think one of the most expensive ones that I did was a tenant advocate requested a jury trial. And so we had to conduct a jury trial on an eviction case, and we won on behalf of the landlord, but we still had to go through all of that. Other ones that get expensive are the ones where we have bankruptcy issues that need to be dealt with, and that causes delay as well as time because we have to keep going back to court for status conferences. So yeah, 4,500 as of 2025, that was our average case value. Next question. The landlord wants to evict the tenant who has lived there for around 20 years. What reason for eviction is better? Number one, moving back to the house, landlord moving into their property. Or two, selling the house, which is what we call withdrawing it from the residential rental market in order to sell it. So I go through the same analysis. Is the lease in compliance with the law? Is the tenancy exempt or not exempt from tenant protections? And that determines what type of reasons we can use for the eviction. If the tenancy is not exempt, it generally requires the owner to have the right to move in as a term of their lease. Most leases, like the California Association of Realtors leases, most of the reliable forms that we see have that in it, already do, but I also have an addendum that I like to use, and we've given it as a freebie that has that additional term in it. And then if the tenancy is not exempt from tenant protection laws, relocation assistance would be required. And the amount of relocation assistance varies depending on whether you are in a city that requires more than what the state requires. The state requires 1 month of relocation, 1 month rent equivalent as relocation assistance. And the city of San Diego, for example, requires 2 months or 3 months for somebody who's elderly or disabled. And there are other types of variations in different locations. We also look at, when we're considering what reason for eviction is better, we also look at what evidence we have from the landlord that supports the reason for the eviction. We look at whether there is any evidence to the contrary, any evidence that contradicts the reason for the eviction. So for example, if the reason is withdrawal from the rental market to sell the house, I like to see a listing agreement. I think that is the most important piece of evidence to prove that the landlord is sincerely trying to sell the property. They have already engaged a real estate professional. It may or may not be listed on the multiple listing service. There are ways to sign a listing agreement and instruct the realtor to keep it off of the listing service for a while. But we can still use that as evidence in court. The evidence to the contrary is when we find that the property is listed on the multiple listing service, but in the listing it says this is a great rental property, definitely selling to an investor. That kind of language that indicates that we're not withdrawing it from the rental market to sell it. We're actually advertising it as being on the rental market, and that contradicts what the landlord has been saying, that they're withdrawing it from the rental market. The downside to using a reason for an eviction that is not supported by evidence is if you go to court and you lose, the tenant may have the right to an award of their attorney's fees. If you go to court and you win, and then the tenant finds evidence that you lied when you evicted them, they can sue the landlord for wrongful eviction and fraud. So those are things to be careful of. You want to make sure that whatever reason you are using is truthful. So then next question, if you choose to move back into the property as your basis for the eviction, how long do you have to live there until you can rent it again? So for owner move-in, going by the guidelines set forth in the City of San Diego's Tenant Protection Ordinance, you have to move into the property within 90 days of the tenant vacating, and you have to stay for at least 1 year. So the City of San Diego is the only place that I've seen that in writing. But generally, I think that's a good rule to stick by. The state of California isn't that specific about it. I don't believe they've changed it to put that detail in there. Next question, for selling the house, if the house does not sell, if your reason for the eviction is that you want to sell the house, but it does not sell, can you start to rent it out immediately? So the word immediately bugs me a little bit, because is that immediately upon deciding to withdraw it from the market? I guess so. You know, that's what I'm interpreting that to mean. So once you terminate your listing agreement with your realtor, you have whatever reasons why the property didn't sell, and you, instead of selling it, you change your mind and you're gonna re-rent it. I recommend the first thing that you would do before you advertise it to re-rent it is you contact that prior tenant and invite them back. And if they don't want to come back, at least you have done the honest thing and let them know, you know, hey, I terminated your tenancy because I wanted to sell it, and then it didn't sell for blah, blah, blah reasons. And now you can come back. By then, they've probably already found another place to live, but at least you tried. What's important in that respect is if you think this might happen to you and you might need to invite them back, get their contact information, make sure you're able to contact them in the future. I would caution you regarding the wording of your advertisement. As I said, if you go to sell it and you advertise it as a great rental property, that could be used against you if the tenant does decide to come after you. Okay, next question. For a no-fault eviction based on removing the house from the rental market, how long do you have to wait before you can rent the house again? So withdraw means withdraw forever. If you remain the owner after you've withdrawn it from the rental market, and then you go and rent it again, your notice to the tenant to terminate the tenancy based on withdrawal from the market is now false. You may not have intended it to be false, so maybe it's not fraud if you didn't intend for that to happen. But as I mentioned before, I think the best thing to do under those circumstances is to try to contact the prior tenant and invite them to come back, let them know things fell through, didn't work out. Do you want to come back and re-rent it? If they refuse, then you're probably okay to re-rent it. What you want to avoid is the appearance that you terminated the tenancy just to get rid of the tenant and you used a false reason. So you want to collect all the evidence that you can to show that you were being honest and things just didn't work out the way you expected them to. Next question. I have a tenant who always pays rent on time, but has never allowed the landlord. So landlord has a tenant who always pays rent on time, but has never allowed the landlord to access the house. Landlord wants to evict the tenant. Which option should the landlord use for the eviction? either the owner moves back in or the owner will sell the house. So this is really similar to the last one, but because this question has the information that the tenant has never allowed the landlord to access the house, I would suggest that a better reason might be that the tenant has not allowed landlord access. So the landlord, in order to prove this to be true, would have to give notice of entry. It's a 24-hour notice of entry in writing. You have to attempt personal service and post it on the door, give it to the tenant in whatever normal way you communicate with your tenant. If you're posting it, if you're delivering it, make sure to take a witness. If it's sent by email, you do have to try to serve it at the property. You are required to post it at the property. But if you also send it by email, try to get a response from the tenant to prove that they received your email. When you post it, take a witness with you who can testify that, yes, it was actually posted. Because then when you go to access the property, if the tenant refuses, or you realize that the tenant has changed the locks, or there's an animal on the other side of the door and you don't feel safe going in and the tenant isn't there to restrain the animal, refusing entry to the landlord is actually a breach of the law and therefore a breach of the lease agreement. The tenant has to abide by the law, and Civil Code Section 1954 allows for entry of the dwelling by the landlord for certain reasons. So there are 6 reasons listed under Civil Code 1954 that allow the landlord access to the property. In case of emergency, and by the way, the statute says in case of emergency, you don't have to post the 24-hour notice. You just have to have a valid emergency. Number 2, you can access it to make necessary or agreed repairs, decorations, alterations, or improvements. You can do that to supply necessary or agreed services or exhibit the dwelling to prospective or actual purchasers, mortgagees, tenants, workers, or contractors, or to make an inspection pursuant to section 1950.5. That's the notice of right to final walkthrough. Okay, so those are all the reasons we generally use under section 2. But you do have to have something that fits within the statute. You can't just go in to do a general inspection. Number 3, when the tenant has abandoned or surrendered the premises, you can go in, or when you suspect they've abandoned or surrendered the premises. Sometimes you go in and you realize that they haven't abandoned the premises. Number 4, pursuant to a court order. And number 5, for the purposes set forth in Civil Code Section 1954.201, which is a section relating to conservation of water and submetering of dwelling units to safeguard landlords and tenants. So if you are doing some work on adding submeters for different units, or doing something that is for the purpose of conserving water, that allows you the right to enter. Or to comply with the provisions of Health and Safety Code section, I didn't put it on here, but it's the section relating to exterior elevated elements and inspection of exterior elevated elements. We've heard a lot about this lately. This is a balcony inspections. So you do have the right to enter to do those inspections. All right, so what would happen is you would, if you give the notice to enter to the tenant and they don't allow the landlord to enter, then you would give a 3-day notice to cure, which says you need to let the landlord enter, and then give some instructions in that notice about how the tenant can contact the landlord to coordinate entry. And then if that doesn't happen within the 3 days, you can give a notice to quit and terminate the tenancy that way, and then proceed with an eviction if you need to. All right, next, a former tenant sued a landlord because the landlord told them that they had to move out, but they claim that they didn't legally have to move out. So the tenant says they didn't have the landlord didn't have the legal right to take possession or to force them to move out. How much can the tenant sue for? So this would probably be a wrongful eviction lawsuit. And under wrongful eviction, tenants have many rights. There are different statutes that can be listed under the heading of wrongful eviction. Some of them are pursuant to, a government notice to fix something relating to habitability. Then that gives the tenant the right to some statutory damages. But basically, under wrongful eviction lawsuits, tenants can pursue actual damages, statutory damages. Some of them are per diem, meaning per day damages for each day that they don't have the required utilities or each day that they are not able to occupy the premises. They can also claim punitive damages, treble damages, and attorney's fees under certain statutes. So it's pretty serious. You don't want to get into a wrongful eviction case. The tenant can also claim breach of contract. Breach of contract lawsuits allow the parties to pursue out-of-pocket expenses, benefit of the bargain expenses, and attorney's fees. So like out-of-pocket expenses would be moving expenses. Benefit of the bargain expenses would be the difference between the rent that they were paying for this property where they were living and then the rent that they end up paying for a different property that's similar, but might be more expensive. If they were getting a really good deal out of their existing lease, it was below fair market value and now they've got to pay fair market value, then they would be entitled to the difference in the rent if they can prove that their new place is similar. There could also be claims of fraud and misrepresentation. So fraud and misrepresentation allows the tenant to pursue actual damages and punitive damages. So if they were wrongfully evicted based on the landlord's misrepresentation to them, like the landlord says you have to move out, but that wasn't actually true. If the landlord knew that they were making a misrepresentation, then that could be fraud. Actual damages. Oh, I just said actual damages can include moving expenses, cost of housing, interim housing, if it took them some time to find an alternative housing unit. Okay. For a wrongful eviction case, will the landlord's homeowner's insurance pay? I don't know. It depends on the insurance policy. Landlords should have a landlord's policy, but they can be different from one policy to the next. So they oftentimes do allow for the insurance company to defend the landlord if there is any claim within the lawsuit that might be covered, but then they reserve their rights as to what they will cover. Could it be a possible business decision? Could the landlord make more money by doing a wrongful eviction? Because they'll rent it out to somebody for higher rent in the long run. I wouldn't advise that. Certainly if you know it's something your insurance will pay for and you have a deductible that you would exceed in profit what you paid for the deductible, I can see how that might be considered a business decision. But I'd be really careful making a business decision based on your presumption that insurance is going to cover you, because they can find a lot of reasons not to cover you. And so I'm not sure that that's going to be predictable. Next question, can a landlord deduct legal expenses and/or insurance deductible payments as a business expense? I don't know. I mean, I'm not a tax advisor, so unfortunately I can't really answer that question. You'd have to consult with a tax advisor because some legal fees, professional fees can be deductible for some people. I don't know whether insurance deductible payments are a business expense. Okay, next question. A 12-month term lease became a month-to-month lease. So the term expired and by default it became a month-to-month lease. Would it be better to terminate the tenancy under the current expired lease, which is month to month, or enter into a new monthly contract and then pursue termination of the tenancy. So if you came to me with this question, first thing I would do would be look at the lease that just expired and determine whether the lease agreement was in compliance with the California Tenant Protection Act and any local rules that apply, like the City of San Diego Tenant Protection Ordinances. Then we would also determine whether the property is exempt or not exempt, all kind of wrapped into one analysis. Once we know whether the lease is compliant, well, let's say it's not compliant. The next step we would do is to bring the lease into compliance. So when it's on month to month, we can issue a 30-day notice of change in terms of tenancy, and we can bring the lease into compliance. We would also want to look at things like whether all of the prior rent increases were within the applicable rent cap, and whether we need to credit the tenant for some rent if there was an overcharge under the rent cap. Then the question becomes, what is the advantage to entering into a new contract with the tenant if you want to terminate the tenancy? So you don't have to enter into a new contract in order to bring it into compliance. The pros, the advantages of a new contract would be bringing it into compliance, because another way to bring you into compliance would be to have the tenant sign a new lease that is compliant with the law. So we can do that. We can do the 30-day notice of change in terms of tenancy, or we can have a new lease and have them sign a new lease that's in compliance. Another pro advantage is you would get a written agreement for a move out. So you can include in an addendum to your lease agreement, tenant agrees that they will move out on a specific date certain. That would be enforceable under the Civil Code 1946.2. One of the at-fault eviction reasons is that the tenant agreed to a specific move-out date and they failed to move out as agreed. So we could proceed with a notice to quit if they don't move out on that date, and then we could proceed with an eviction. The disadvantages, the cons to entering into a new contract is that it's kind of misleading. You're even if it is a new month-to-month contract, you're kind of leading the tenant to believe that they can stay and then turning around and trying to evict them. So there's that. I would be concerned about that. If you intend to evict them, I would not enter into a new lease agreement unless one of these other reasons is more important. Okay, so can a monthly lease be terminated at any time? So the house is in La Jolla, California. This depends on compliance and whether the tenancy and the property is exempt or not exempt from tenant protections. So if you are exempt from tenant protections and it's a month-to-month tenancy, then technically you don't have to have any good reason for the eviction. But we still recommend having a good reason because of tenant defenses like retaliation and discrimination that come up. If you can't tell the court why you needed the eviction and the tenant says, well, I complained about mold a month ago or 2 months ago, then the court might interpret that to mean that you're evicting the tenant because they complained about the condition of the property. That's not good. So that's if it's exempt, you don't need a reason. If it's not exempt, then you can't terminate at any time because you have to have a valid at fault or no fault just cause to proceed with an eviction and terminate the tenancy. Okay, what's the best reason for an eviction? Either removal from the rental market, or the tenant refused to allow the landlord access to the property, or the lease became a month-to-month lease. First, the terms get mixed up all the time. Termination of tenancy versus eviction. These are two different things. You have to terminate a tenancy first before you can evict the tenant. So termination of the tenancy is where you need a good reason. And then you test that reason when you go into an eviction. So just for clarification, we try to terminate the tenancy without the need for an eviction. And generally, if all goes well, the tenant moves out without needing to be evicted. And if we do our job right, we should have the tenant, if they consult legal counsel and their legal counsel says, yep, your tenancy's been legally terminated, you should move out, then hopefully they move out. That doesn't always happen. So then we look at the lease for compliance, whether it's exempt or not exempt, and then we determine, so what's the best reason for an eviction? So an at-fault eviction is usually the shortest kind of eviction because we generally can do a 3-day notice to cure the breach and then a 3-day notice to quit. And as long as the tenant doesn't cure the breach, we can proceed with an eviction fairly quickly. A no-fault eviction. So I'm sorry, I need to define the at-fault. At-fault is where the tenant is in breach. No-fault eviction is where the tenant didn't do anything and the landlord has found different reason to terminate the tenancy. No-fault evictions usually take longer because we have to do a 30-day or a 60-day notice to terminate. So we have to wait out that notice. But I wouldn't say that either one is better than another. What we look at when we make these decisions is what does the evidence support? Does the evidence support that the tenant has breached the contract? Does the evidence support that the landlord needs to move in or that the landlord is going to sell the property? So it all depends. Also, it's important to look at the lease and determine whether the lease is month to month or has an unexpired term, because you can't do a no-fault eviction if the lease term has not expired. You can't just interrupt a 1-year lease at 6 months because the landlord decides they want to move in. You have to wait it out. The landlord can't move in until that lease goes month to month and you give proper notice. So that's also an important factor. The question was raised whether you can find a contingency-based attorney for an unlawful detainer for a landlord, and that would be very unusual. Sometimes you'll find them on the tenant side, but on the attorney side, not so much. On the landlord side, not so much because tenants don't usually have a lot of money or assets to collect from. It's different on the commercial side. I did not get very far through this outline, so maybe we'll use the rest of this outline for next month's webinar because I'm about halfway through and didn't realize how much I would be talking at you guys. The other subject matters that we haven't covered yet are habitability, commercial tenancies, rent increases, and discrimination. So pretty broad range. I only got I didn't get very far through it. So thank you so much for coming today.